Welcome back. Let us start our next panel, which will be exploring the state of the art of artificial intelligence in litigation. So, joining me are a really accomplished and expert group of panelists. In the interest of time, I will be only providing brief introductions, but I recommend that you look to their very impressive accomplishments, which are linked on the conference webpage. Joining me are Dr. Maura Grossman, who's a research professor at the David R. Cheriton School of Computer Science at the University of Waterloo. Also joining me, Daniel Linna Jr., who is a senior lecturer and director of law and technology initiatives at the Northwestern Pritzker School of Law and McCormick School of Engineering. And last but not least is Rebecca Wexler, who's an assistant professor of law at University of California, Berkeley School of Law, and also the faculty co-director of the Berkley Center for Law and Technology. So thank you so much. I'm so pleased to have such a great group of panelists joining me in this really interesting topic. And if you were there at the last panel, and even if not, I explained to our audience how our conversation aims to be rooted in the evidence of artificial intelligence. We're trying to be free of hyperbole and exaggeration and really focus on the actual and current state of AI, both where it is excelling, but also in light of its limits with respect to, abstract reasoning and cognition and what have you. And somebody who's really done a lot of interesting work in this area is Maura Grossman. So I will turn and ask the first question to Maura, and then we'll open that same question up to the rest of the panelists. So, Maura, let me ask you, where are we seeing artificial intelligence gaining a foothold in litigation today?
I think it's helpful for us to look backwards first and review the history of how machine learning first came into litigation. In December 2006, there were amendments to the Federal Rules of Civil Procedure that introduced the term ESI, or electronically stored information, and e-discovery became a thing. The volumes of data were increasing beyond what law firms and lawyers could handle in a typical litigation in discovery to review them. Perhaps back then, a large case was 35,000 documents. Today, it is very easy to have 10 million documents or more. And in the 2007 or so timeframe, there was the birth of something called the TREC legal track, which was run through the National Institute of Standards and Technology. They're the folks in DC who measure things. So if you go there, you can see the official ruler and the official pound and the best Kevlar vest that's most bulletproof and so forth. And Jason Barron and a few others approached the National Institute of Standards and Technology to help with looking at and measuring search methods. And I first became interested in the use of supervised machine learning to distinguish between relevant and non-relevant documents using labeled training examples where the algorithm learns to distinguish the features between relevant and not relevant. But how do you convince others when they think you're on crack and aren't inclined to believe you that this stuff works? So we decided to do an empirical study, and we worked on that from 2009 and on, and it was eventually published in the Richmond Journal in 2011, where we first coined the term technology-assisted review, or TAR, and we showed it could outperform attorneys at finding relevant documents, both in terms of efficacy and efficiency. In 2012, the first federal and state court cases accepted the use of TAR, and now we're in 2021, and it's been a decade, and adoption has been slow. Tech has definitely improved, especially with the uptake of what's called continuous active learning, or TAR 2.0, but there's still resistance due to concerns it won't find the smoking gun, that producing parties will game the technology by mistraining it, or small coding errors will lead to disaster. There's discomfort with loss of control. We know lawyers are control freaks. And loss of money by law firms and service providers. So there's some unwillingness to learn how the tech works, and a lack of desire sometimes on the part of producing parties to even find bad evidence. So the incentives are completely misaligned. But today the fights are no longer about whether the tech works and a party can use it. I think adoption has increased, although it's still not ubiquitous. The fights are over process and evaluation of the results. And I think the industry has failed to take science and statistics into account properly, which I find really disappointing. And the case law has simply not developed in the most empirically sound or valid way, but it is here, and it is pretty entrenched.
So it sounds like you're seeing the technology of electronic review really improve over the years, and perhaps even meeting or exceeding attorneys in many cases, but the incentives are not really aligned for this to gain widespread adoption in some cases. Yeah.
I think that's true, or at least as much adoption as I would have liked to see after a decade.
Great. Dan, do you want to react to the question about where you're seeing artificial intelligence gain a foothold?
Sure. So I just kind of jotted down some notes. I think where we're seeing some, I mean, it depends how you define foothold, right? We're seeing tools. We're starting to see them used. If Maura is not that bullish about adoption of e-discovery, then I suppose I can't be too optimistic about these other tools. They're not being used as widely yet as e-discovery. But I think we could look at AI, first of all, thinking about this litigation ecosystem is something I'd like to talk about, because I think sometimes we focus too much on kind of point solutions and don't think about how the whole ecosystem is evolving and will continue, I think, to evolve over the next few decades. We can look at the way AI is helping attorneys. That's mostly, I think, what we'll be talking about today. But there's AI helping individuals, individuals or maybe even legal departments, AI being used in courts, and AI being used in the administrative state, I think we could look at as well. But for AI, for attorneys, e-discovery is the most prominent example. Legal research actually is actually even more broadly used. Of course, a lot of that's kind of not necessarily so visible to the users, but we see more and more tools where AI is really improving legal research tools. But I think we're seeing more and more drafting tools as well. Tools that, given a complaint, can draft an initial answer to the complaint, that can draft discovery requests, responses to discovery requests, motions in briefs. And I think we'll see those tools continue to be used more and more and get better and better. And analytics, a lot of times people will lump in that bucket. I think we're going to talk about that a little bit later, but we're seeing more and more use of descriptive analytics and even building some models to predict costs and outcomes. On the AI helping individuals side, we're seeing more and more development of expert systems helping with a wide range of problems. Some of this can be in legal aid organizations, but then there's big law firms, as we heard on the prior panel. I liked hearing all the discussion about good old-fashioned AI and rules-driven systems. I mean, a few years ago, people seemed to think, rule those out. And I completely agree with the prior panel that there's a ton of work that we can do there, creating, in the legal aid space. We see tools for bankruptcy, divorce, landlord-tenant, but in the big law space, there's a lot of opportunities. We see, here in Chicago, there's a tool for tenants, helping them in landlord-tenant disputes. It's called Rentervention. It's a chat bot. So it's got a foundation of rules, but then it uses natural language processing so that when different queries come in to try to match them with the right sets of question and answer pairs. We're seeing more and more use of AI in courts in a lot of different ways. I think the rise of online dispute resolution is really going to change the way we think about litigation. And a great example is the British Columbia Civil Resolution Tribunal. There's a lot less focus there than on adjudication. It's more about empowering the parties, helping them understand their rights and responsibilities, and resolving disputes without attorneys, right? In the vast majority of these cases, it's without attorneys. And then we can see in the administrative state more and more use of algorithms There is examples like adjudication of Social Security disability benefits. One use there is this idea of easy grants. Can you create an algorithm to kind of identify cases where this is absolutely, we should grant benefits here, and the person shouldn't have to wait 8 months or however long it is. But then also seeing AI and algorithms being used for regulatory enforcement, such as by the Securities and Exchange Commission. So I think we're seeing a lot of activity in a lot of areas, and it might not look like adoption is taking off just yet, but I mean, I think we're at the slow growth kind of stages for a lot of these tools.
Yeah, Dan, thank you. That's a great perspective, and I really appreciate you surveying the ecosystem, because I think that's a really important way to look at it. And one theme I'm hearing from both Maura and you is that attorneys can actually gain competitive advantages by adopting relatively simple, it doesn't have to be that fancy technologies that have proven themselves, whether it's e-discovery or even basic predictive analytics. And I think that's the case, and maybe more attorneys will move in that space. Rebecca, let me turn it over to you. Do you have a reaction to where you see artificial intelligence taking hold in litigation?
Yeah, thanks. So thanks so much for organizing this and for having me. Really excited to be here with the other panelists. And I know later on in the panel, we're going to do a deep dive into evidence issues and predictive tools. So I'm not going to talk about those here. So just in reaction to what Maura and Dan just said, one of the things I'm not seeing is the adoption of AI assisted discovery in criminal cases. And I've wondered why for a long time. And it maybe is something that Maura said, in the civil, you've got this huge expansion of the volume of documents. And in criminal, there's a lag, I think, in that. Nonetheless, criminal cases are starting to struggle with document dumps, that maybe even there could be challenges to Brady disclosures if the prosecution has handed over, 10 hard drives worth of content without a map as to what might be most pertinent to the defense. That could overly burden defense counsel's limited resources and kind of be for practical purposes, obstruction of the relevant disclosure of information the prosecution's obliged to provide. So I think there's a opportunity there, to Harry's point, that maybe we could even gain some real advantages in fairness and efficiency and accuracy just by starting to import some of the tools already developed in the civil space into criminal. But to kick back a question to the three of you, more about the TAR technology than I do. What do you think are some of the, and we don't have to answer this if it gets out of our order, but what do you think are some of the reasons why it's not being adopted in criminal, even to the extent that it has been in civil? Is it this volume of documents problem where you have to have a certain amount of documents in order to make it pertinent? No, so that's a good news. I see Maura shaking her head. That's a good news for criminal cases. What might it be?
Cost.
Sorry, cost.
Cost, yeah.
Why is it so expensive?
Yeah, well, that's a really good question. Because it is often charged at a per gig price based on volume. And so the savings is significant, probably once you get over 15, 20,000 documents, something like that. It can be used on smaller cases, but for the most part, you have to look at what am I going to save on the document review versus what am I going to pay for processing, hosting, and often not always paying for the switch for the analytic tools. Sometimes they're included, sometimes they're extra. So my guess is that the driver is probably cost, especially for public defenders or solo attorneys who are defending somebody, because maybe in the white collar cases, it's being used a lot more. I think it was definitely used at the firm I was at for white collar, but not so much for individuals, because my guess is cost driver.
Really interesting. Oh, sorry.
Oh, I was just going to ask more. I think that's fascinating. Is it your impression that the cost has to do with the special requirements of law versus other areas of machine learning where you don't have to be quite as careful in terms of privilege and security about data, say when you're analyzing images, or could the costs come down and they just haven't for various reasons due to
the costs will come down as it becomes more commoditized. It doesn't cost any more to search 1 million documents than to search 70,000. It really doesn't in terms of the machine learning. It may cost a little more to host it, but there's margins here. And it just hasn't commoditized enough to come down. You are starting to see the entry of players, smaller players who are gearing towards modest size cases and smaller cases. And I think with time, I think it's going to be embedded in all of the tools and it'll just be there. But I think that's primarily it.
Dan, did you have a reaction to that?
Well, no, I think it's a great set of questions, and I hope the cost does continue to come down. And I think, Rebecca's the expert in this area, but my sense is that there are tremendous opportunities for us to think about how to use technology tools, for public defenders and for other folks that we can really improve criminal justice. And, I'd love to see people like all of us inside of our universities working more on this too, right, to help contribute to that.
I second that. And I just to jump in and think maybe one solution in the criminal space would be who bears that burden of cost, because it is the prosecutor's a repeat actor. And to the extent that, say a slew of misdemeanor cases, the prosecutor is going to be getting, say, 100,000 misdemeanor cases, maybe they've got repeat fact patterns, and this could scale and be efficient if we impose that cost burden on the repeat player.
Yeah, the challenge is not all prosecutors have access to this either. I mean, I know SEC and some of the DOJ units do, but I don't know if line prosecutors do in regular cases. They may very well in big antitrust they do in antitrust and those kind of cases, but smaller crimes, not so much. So it's not on either side.
Yeah, so this might be a real realm of improvement where we could, unleash some benefit if we lower the cost and access issues. Fascinating. So in the last panel, and we spent a lot of time on focusing on the limitations of AI, making sure that we're not overpromising or exaggerating. So let me throw this out to Dan first, and then the rest of the panel initially. What limitations are you seeing about AI use in litigation? Where are there promises that are exceeding reality?
Yeah, I think it's a really interesting question because there is some unreasonable hype about some of these tools. And I think that, we see kind of high level articles sometimes written about robot lawyers and robot judges. And then I think we tend to focus on the hardest versions of problems like, robot judge and what's it going to be like with a robot judge that replaces a jury in a murder trial. And it's like, well, slow down. I mean, I think there are a lot of other areas where we might use technology for lawyering or in judicial processes that might automate or augment things. And I think there are actually a lot of possibilities. If you think about, a robot judge in a murder trial seems very fanciful right now, but what about for a traffic ticket? Or what about for a landlord-tenant dispute? And, so I think we need to get more specific about some of these questions and start asking really thinking more about, well, what's possible and where can technology help us improve the legal system, help us improve rule of law and access to legal services. And I think, one example is you mentioned autonomous vehicles in the opening, Harry, and you think about the billions of dollars that have been invested in creating autonomous vehicles. And we're nowhere near that sort of investment in creating legal technology tools. And I think there's a real university research gap in this space as well. I think you look at some of these other areas, the way universities have contributed research to advancements on autonomous vehicles and other areas. And I think that's, again, another area where I'd like us to see us do more in universities to contribute to developing these tools for legal services, for legal systems, and thinking about how the law might be represented in the future. And so I think that, to some extent, to me, some of the biggest obstacles that we face are thinking too small, and then at the same time, magical thinking. And I think a lot of the ways that we're trying to use AI right now is kind of like these point solutions and trying to automate things the way we've always done them. So that's only going to get us so far. And I'd really like us to see us talking more about really having a vision for the future on thinking about what these systems could look like, what's legal services delivery, how are we going to disseminate legal information, what do legal services look like in a digital world that we see emerging. And then if we can kind of have a better vision for what the future might look like, then we can better identify the obstacles to us getting there and doing that. Now, so at the same time, though, I think this magical thinking, right? AI is magic. We can just throw AI at some of these different problems. It requires more than just purchasing technology tools, whether you're in a law firm, legal aid department, or anywhere, right? And I really think we need to be having more of a people, process, data, and technology approach, right? Thinking about that ecosystem, and then helping us be rigorous about developing this roadmap of the research that would make it possible. And just so thinking about people, process, data, technology, I was going to briefly mention just kind of each of those where I see. So data, right? So today we can say oh, AI, it's a data problem. We don't have the data. There's confidentiality. We can't get the court data. I think that we haven't even really spent a lot of time thinking about what data we need. And sometimes some of the different projects that are done are kind of well, here's some data available. What can we do with it? And that's kind of a backwards way to go about it. So I think we need a lot more thinking about what kind of data we need to be able to develop the kind of tools that we want to have. And how do we get quality data, which I think is a big problem. That leads to the process problem. I think we lack standards and best practices in many areas of law. This came up a little bit on the prior panel, how do you measure the outcomes? I love that this came out, right? This is something I've been doing a little bit of research. If you get something that a machine generated a draft and a lawyer wrote a draft of a answer to a complaint, what's the quality of them? What are the standards? How do we measure the quality of different things? If we can't measure the work that's done by lawyers, how could we evaluate the outcomes that are produced by technologies? And I think that so part of this will be, as we're putting these technologies in place, I see more and more work that's being done. Legal operations is really growing, and people are really thinking about how is it that we solve problems? What are our processes? What's the work we do? So we're moving from being artisans and craftspeople to taking on more of an engineering and scientific approach. And of course, as that starts to happen, as we see more standards and best practices, it starts getting easier to use technology. It starts getting easier to automate things, to augment things. Richard Susskind's talked about this for a long time, right? Kind of moving from bespoke to standardized to systematized to commoditized. So I think that in this ecosystem, we're going to see more of that some of these problems that look really hard will start to get easier to solve as we take this more disciplined approach. And then people, right? We got to train lawyers. Lawyers need new skills, I think, in this ecosystem, not just learning about technology, but learning about project management, process improvement, computational thinking and data analytics, leadership, change management, learning about how innovation occurs. And then we need more and more of other professionals coming into this space, not just technologists, but also project managers, process improvement experts, data scientists. And then thinking more broadly about technology, right? Like I said earlier, I was thrilled that the prior panel talked about more than just machine learning and deep learning and transformers, but talking about good old fashioned AI, talking about the other ways in which technology, just basic technology, has the power to transform courts and legal systems. So I think, if we have this vision for where we're going, what we're really trying to accomplish, and we take this people, process, data, technology approach, then I think it'll make it easier for us to really understand, right? You talked about being evidence-based and measuring things and things like that. Well, then how do we really understand, what are the obstacles, and how do we start focusing on how to overcome them, kind of one brick at a time, building this foundation for this future that we want to have.
Dan, those are some really great points. So thank you for that perspective. And a few points I want to highlight I think are that a lot of us can relate to the role of universities in kind of spurring this kind of basic research out there and making sure if there's access to justice or other issues that we take on that cause, because they may not be as likely to be solved by the private sector out there. And also this idea, which I'd love to hear the panelists thought about, the data bottleneck in law, thinking about what data we want and how to get representative data, not just the data that happens to be accessible. One of the issues in law, which I know you, Dan, and I have spoken about before, is this idea that a lot of legal data that could be subject to useful practices out there to help society are protected by secrecy and confidentiality agreements in ways that you don't necessarily see outside of law in areas. But let me see if Maura or Rebecca have reactions to either Dan's comments or just questions about the limitations of AI.
Sure, I'll start. One of the challenges I think in this area is the following. If I want to go buy a refrigerator, I can get pretty good information from Consumer Reports or something else about the quality and sort of standard comparisons. If I want to buy an e-discovery tool, there's no Consumer Reports. It's complete Wild West. And that, I think, applies to most of these things, which was Dan's point. You're getting something that drafts responses, answers. How do you know it's any good? And I think it becomes very hard for the user to distinguish good tech and process from poor tech and process. And I think that's compounded by the fact that most lawyers don't have a good understanding of measures of evaluation. And they will see something that says 99.9% accurate and have no idea that they need perhaps to look at false positives and false negatives and different kinds of errors. And I've seen all kinds of misrepresentations of metrics. I'd like to think is accidental rather than intentional, but you know, to the average lawyer, if you say the recall being what percent of the documents are found, the recall is really 49% plus or minus 20% margin of error. You know, their eyeballs start to go back in their head and the vendor tells them it's 70% plus or minus 2%, and they buy it and they have no capability of analyzing those representations.
That's fascinating. So do you see a role for intermediaries here, like the Consumer Reports of legal analytics, or what is your thinking in that area, Maura?
Well, it's hard to do that. I think Trek tried to do that kind of standardization, at least, or evaluation, but often providers don't have the incentives to come because they can be found to be worse than the guy next door. I was hoping that the judges would do it, but they have a hard time with the technology, and any one matter may not justify the kind of Daubert hearing you might need to get to the bottom of what works or not. So you have a busy judge and two competing experts, and they don't know what to do. And so it's a real problem. But setting up an independent entity, you can get sued. So it would, and you can get sued a lot. My understanding is Consumer Reports get sued an awful lot. So you need a huge legal department with a lot of money that's prepared to deal with those lawsuits when they come in.
Yeah, so perhaps this might be another place where universities could play a role as some sort of trusted intermediary. Rebecca, do you have any thoughts either to Maura or Dan's questions or the original question?
Yeah, well, I want to echo the emphasis on universities as solving market problems, because one of the limitations I see on AI in the criminal space is specifically how distorted the private sector is in the development of the tools. So there's distorted access to data, and there's also distorted incentives to develop the technology is based on who's going to pay for them and who's going to buy them. So if the prosecutors, the government, are the paying customer, then we can expect that any errors, reliability, flaws in these technologies are likely going to be less caught, less observed, less corrected when they favor the prosecution's interest. And so universities might be a place where we could say, hey, let's start developing technologies and designing technologies that are specifically aimed at serving interests of innocence, for example, rather than serving investigations of guilt. If the market's not going to make those tools, maybe the university could. And then I saw some questions in the Q&A. So just how reliable is data in police reports as an example. You know, it really depends on what the data is, but race data in police reports, super unreliable. We don't know whether it's observational or self-reported. When I was practicing, we would have the same client appear in different arrest records with different races put down. Geolocation data, maybe that's more reliable. You know, so another example from a few years ago when I was in practice, arrest data saying law enforcement had arrested you know, multiple people. Well, this kind of actually goes against it, but multiple people at the same moment in time. in different locations, same police officer in the report. So that's a kind of reliable tell that something's wrong there. In any event, and then police disciplinary records. A lot of people say, well, we want to get access to those records and maybe run predictive tools on them or something other, but there's huge problems with disparities and bias, even in the disciplinary process for law enforcement. That could make some problems with that data.
Great. Thank you for that perspective, Rebecca. And I'll add to that because I've studied some of the distortions that go into police data and criminal data. And one point that other commentators have made, but if police practices themselves are biased in some way, it biases the data. So a good example is certain neighborhoods get patrolled more than others, and just the very act of patrolling one neighborhood versus others, even if the crime rate is exactly the same in two neighborhoods, you're going to lead to more arrests lead to more recording of data. So it's going to appear that certain things are more correlated with crime than other things, but that's solely driven by police practices. So, and that's just an example of the way that which practices can distort the data, and these models are built on data. So that's a really great point. Any other comments, either Dan or Maura, to Rebecca's observations?
Yeah, Harry, I was just going to add something after Maura's points really briefly. Well, she raised this question too, like of lawyer education, right? Lawyers need to understand the right questions to ask, and we can be training them to ask these questions. But I also think we can learn a lot from what we're seeing develop in other areas. You look at the Algorithmic Accountability Act, and if that were ever passed, right, requiring impact assessments and things like that, why aren't we requiring that in this space, right? And so how do we train lawyers to ask the right questions of vendors? And why aren't vendors disclosing more information about how these tools are validated, and where did the data come from? What sort of validation did you run before you release this in the wild? Now that it's out in the wild, how are you continuing to validate that it actually works, right? So part of this is creating that marketplace where the buyers are asking the right questions and demanding that the suppliers, I think we're seeing that start to happen in other spaces in the AI landscape, but so far, it hasn't seemed to really happen yet in the AI for legal services tools market.
I'm working, Dan, to that point. I'm working with the group with colleague Jeremy Pickens, who's in this space, and I are chairing a committee that is actually writing a whole process for how lawyers should vet AI tools, what questions they should be asking, how they might actually perform an evaluation and so forth. So stay tuned. There may actually be something in this space. It's through the EDRM, which is the Electronic Discovery Reference Model. It's an industry organization.
That's great. And one area I'd like to see growth in that area related to Maura and Dan's question is the purchasing by government of AI systems. So governments are notoriously lacking in expertise in how to analyze systems, validate them, and then use them. So we've seen this in the Compass recidivism systems where, trade secrecy protects us from validating the accuracy of the underlying results of these systems that produce reports that judges rely on and deciding whether people go to jail or not. So they're deferring to numerical scores from these systems produced by third parties that may or may not be accurate or subject to biases or distortions. And typically the government doesn't really have the expertise to figure out one way or the other. So I'd love to see more work in that area. Let me turn to Rebecca and ask you, how is AI impacting and being used in the context of forensic evidence? And that's another area where we're seeing it being involved in the litigation space.
Yeah, absolutely. So this is the area where AI is coming into the criminal legal system the most, apart from the predictive policing and recidivism tools. So, as many of you may know, there have been a lot of problems with specifically pattern matching forensic methods, with junk science coming in, blood spatter evidence, image recognition, trying to match somebody's identity based on the stitch pattern in their fabric. I mean, all sorts of stuff that's not scientifically valid or hasn't been scientifically validated, with no error rate and overclaiming about the confidence of these testimonies. And this is without any technology involved, just humans eyeballing stuff. So I think there's a well-intended attempt to improve on that pretty horrible baseline by trying to automate some of the pattern matching forensics. And so we're seeing machine learning driven software being used in maybe most widely known face matching, shot spotter, bullet shot recognition evidence coming into cases, but also DNA analysis for complex mixtures of DNA found at crime scenes, fingerprint analysis, bullet mark identification, voice matching, iris matching, handwriting authentication, authorship authentication for tweets. You know, is this the kind of tweet that you generally say? Using some software to analyze and give us a result. So that's already here. There's no question that's being used in many, many, many cases daily. And there's huge problems with it. Real problems around access to scrutinize these tools, expertise needed to scrutinize these tools. So let me just run down a couple of ways that I think that the evidence rules are failing to impose kind of reliability, transparency, fairness, constraints on this. So we generally turn to Daubert or Frye as our reliability rule for admissibility. But it turns out that the courts say experts can testify under these standards based on the outputs of systems that they don't understand. So you have a problem with experts getting up on the witness stand and they know just the basics. Well, here's how I use this thing. I input something, I output another thing. I did a cursory internal or validation in my lab. And so there you go. And then you say, all right, well, okay, you know, the Supreme Court told us the traditional way to challenge shaky but admissible evidence, despite Daubert, is cross-examination at trial. All right, so maybe this is really about cross-examination at trial. But where do the rules get you cross-examination? So one way is if we say these things might violate confrontation clause rights if the developer, the designer weren't brought to be cross-examined, and you'd be able to compel somebody who has knowledge about the systems there on the stand. But courts have said no. You know, automated systems don't really create statements the way humans do. So we don't think that they're hearsay. We don't think they're testimonial hearsay. We don't think they implicate the Sixth Amendment. So that doesn't get you much on cross-examination. And, you know, if you try to go discover information about how the tools work yourself with a subpoena, you may encounter privilege problems. And that's where our intellectual property rights are coming in to block discovery or subpoenas. Also, some security rationales for denying, say, criminal defense counsel access to information about the tools if you think excessive disclosures might lead to gaming or circumvention. So I think that our biggest challenge as legal scholars in this criminal evidence space around AI is figuring out how our old rules of evidence can help us ensure fairness, accountability, and due process values, given that these tools are actually already here.
Rebecca, that's terrific. And just to follow up a little bit, do you have any ideas about specific changes? An example where you've seen an expert testify about a system without knowing its internals and how that specifically could have been improved?
Yeah, well, actually, I think there's again a role for the academy here, but one idea I've had that I've been unable to deliver on so far, and I would love to, you know, if anyone's interested in working on this themselves, go right ahead. If you're interested in collaborating, like, let me know. But I've had attorneys say to me, what would be really useful is if someone in the academy could write scripts for defense counsel to cross-examine ignorant experts on the stand. What are the questions defense counsel could ask when, say, for instance, you know, somebody's on the stand saying this is data that we extracted from a device and we know that it hasn't been tampered with and it's exactly what was there, and you don't know how the device operates. That's not an AI machine learning one, but okay. So DNA analysis. You know, what are the subjective design choices that went into the software you're relying on to come up with a probability that my client's DNA was included at the crime scene? And so one of the opportunities is that as the same technologies are used across many, many cases all over the country, there's actually economy of scale, ability to share knowledge in the defense side that maybe never was there before when you're having custom case-by-case facts. Academy could create these scripts for cross-examination and distribute them free of charge. Let's do that.
All right, I love that idea. Maura or Dan, do you have reactions either to the initial question or to Rebecca's comments?
Sure. So as Dan knows, since he strong-armed me, I'm about within the next month to publish a piece, which I think, Rebecca, you're going to get an opportunity to comment on AI
I'm
as
looking
evidence.
forward to that.
And it's in the Northwestern Journal of, is it Intellectual Tech and Intellectual Property, or the other way around? It's one of those two.
JTIP. Yeah.
JTIP, Intellectual Property. And we're very excited about it. We actually take the position, I wrote the paper with Judge Grimm, who's probably one of the leading experts on evidence out there. We take the position that the current rules can work if parties in the courts actually know how to use them. And we also take the position you should not be able, as was done in the Wisconsin v. Loomis case, you shouldn't, especially in the criminal sphere, you should not be sentencing somebody and then saying, sorry, this is intellectual property. You don't have an opportunity to challenge this algorithm or learn anything about the data it was trained on. We respectfully feel that the Supreme Court in Wisconsin got that wrong. But there's also a point, I think in a lot of these situations, you're going to need more than one expert. You're going to need the expert who said, I pushed the button and the result popped out is not enough. You need the other expert who can say, well, this is how it works. And this is how we validated it and all of that. And right now you're only getting that first expert who says, I pushed the button. And then when you ask them, well, they don't know. And so it's sort of a circular firing squad at the moment. But I think there have been virtually no courts that have really had to address the admissibility specifically of AI evidence. So there's not a lot of precedent there, which was what we tried to do, was to provide some advice, maybe not exactly the questions, but we do give a playbook of not only how to get it in, but also how to challenge it.
Maura, those are great. And I fully agree with you. I think when private vendors are selling to governments, there are certain special restrictions that have to apply. And you see this very commonly given life and liberty at stake. And one of these, I think, should be the requirement that things like source code and transparency, third parties can always choose not to sell to the government, but when they do, given the stakes involved, I think that they should be required under the proper circumstances to show source code or data. Dan, do you have any reactions to either Maura or Rebecca's comments?
Yeah, I mean, just on that point, I would love to hear Rebecca's thoughts on how we go about changing the rules. Like, where do we start to require that? Because I think it's, there was a lot of criticism of the Wisconsin Supreme Court in Loomis, and people thought, oh, they should go to the US Supreme Court. But, I'd like to see more advocacy for saying, well, let's change the rules. Let's change the rules of criminal procedure. Let's put statutes in place, whatever we need to do to make sure that this doesn't keep happening. I think one of the other thing that was interesting is, junk science has been a problem in the courts for a long time. Bite mark identifications and things like that have, put people in prison. So this is, in some ways, this isn't a new problem. And I think this relates to some of the questions about bias that I've seen in the Q&A and chat. And, I think one of the things that is interesting in this area as well, making sure good tools are used in this space, and there's worries about bias resulting in less fairness, less justice in court systems. I'd submit that the status quo isn't so great, right? And so I think there's some pretty big opportunities to think about how can we responsibly use these tools. a lot of them are pretty painful failures. A lot of times when we read about these tools, just terribly unrepresentative data that if it had been properly validated, and as anyone thinking at all would have said, well, wait a second, why would we think this would work in this context? Lack of diversity in the teams developing and implementing and using these teams, failures to train people. I mean, there was a terrible case in Detroit where Robert Williams was arrested based on face recognition tool being used. And there was a lot of outrage about the face recognition tool, but it seemed pretty clear, and the police even admitted that it was not used properly, right? It wasn't used as an investigative tool. It was just like, oh, here's a match, let's arrest this person, right? So there's, I'd like to see that there's some promise here. No doubt bias and the errors that these tools can make are problems, but I think a lot of the things are things that, by more rigorous validation and employing best practices, they're errors that could be eliminated.
Dan,
go
ahead. Yep, Rebecca.
Well, can I jump in? Just Dan said, what to change. So let me I want to give a pitch on that, because I gave a pitch on folks developing a script for cross-examination. I think the thing that lawyers are best suited to change are the rules of procedure and evidence. And so can we make them tech neutral, but strengthening the opportunity for as applied adversarial challenges on a case-by-case basis? I think a lot of the discussion about what to do has tended to go to centralized standards creating bodies, audits, NIST approval. And my answer to that is yes, and. Yes, and we purportedly have an adversarial system that relies on cross-examination and adversarial scrutiny in an as-applied case-by-case manner. And it's our responsibility as lawyers not to allow the development of technology to curtail those adversarial due process values. So some concrete changes. I've argued that the trade secret evidentiary privilege should not apply in criminal cases, that's not a legitimate reason to withhold relevant evidence from the defense. That's a purely legal argument. It is not text specific. It's not saying source code always has to be disclosed. It's not saying, only executables or what have you. It's have a debate with the experts in every case on what details are relevant in that instance, but have the debate on the legal standard of relevance, not heightening it to some impossible to meet necessity burden because you're giving special treatment to information on the intellectual property values. Same thing's happening with privacy. So more recently, I've been arguing certain privacy statutes should not block criminal defendants' access to relevant evidence. If we really believe that we can rely on cross-examination and adversarial scrutiny, we should design the legal rules to permit defense counsel to access relevant evidence.
One quick response to that. I think, Rebecca, we also need to plead with our judges to really apply Daubert. Often the leaning or the tendency is let it in and the jury can worry about it. And the problem is the jury is in no better position to figure out whether it's valid or not. And we really need the judiciary to really tighten up that initial gatekeeping function.
Good point. Good point. I agree. And so the ability for defense counsel to cross-examine in the Daubert hearing also has to be defended so that judges can do that job. So get our pretrial subpoenas power back, get our constitutional rights that have been watered down pre-trial, get those back. And it might help judges do exactly what Maura said we need to do, which is really apply Daubert.
Okay, so before we turn to questions for our audience, I just want to have one quick reaction to, I think, a really important topic, which is predictive analytics. This is the use of data and in some cases machine learning to make legal predictions about outcomes of cases or damage awards or other sorts of important facts. So I'd love to hear everybody's thoughts on that trend.
I'll just jump in. I think we are seeing more and more of this driven by clients, particularly corporate legal departments. They want to see their lawyers using data to predict how much something is going to cost is a place where there's been a lot of work done, thinking about staffing of lawyers as well. And then more and more work on predicting outcomes, though I think in a lot of ways that is not nearly, there was a lot of talk about prediction 5 years ago even, and I think a lot of it is mostly just descriptive statistics. One thing I would say is, again, this is a data quality issue. There was a study done a couple years ago looking even just across like Westlaw, Lexis, Bloomberg. I shouldn't necessarily say data quality. It's just that in these different platforms, the data is not cleaned and represented exactly the same way. So you might get different numbers across these platforms based on what you're looking for. So that's one of the things we need to be aware of. And then just the lack of access, right? PACER is still locked up. Now, maybe Congress will change that and pass the law to free the PACER data. But you know what? I would love to see academics spend more time looking at state courts as well. We tend to focus on the Supreme Court and the federal courts. This is a huge problem in state courts. And right now, state courts are several of them are thinking about investing and improving their systems. Let's have them put in place systems that make that data accessible to the public, to all of us, and that would be a huge step forward.
So I agree with I agree with Dan. I think uptake has been relatively limited in these predictive tools, other than you can find out how long it takes your judge till they file a summary judgment, the response to a summary judgment motion, but getting a prediction on how likely he's to rule or she is to rule one way or the other, much harder. I dipped my toe in this area with machine learning, and I was actually very surprised at how few of the litigation funders are using AI at all. And I think there's also a challenge, because when I approached plaintiffs' lawyers and some of these litigation funders, and I said, how do you know what's a good case? What do you rely on? What are the criteria? They don't want to share them. I don't know if they couldn't articulate them and it was just something they know in their gut, or they felt it was proprietary. But if you can't define the criteria of success or winning or whatever, then it's impossible to train the algorithm to do it.
Rebecca, any thoughts?
Well, predictive analytics changing the practice of criminal litigation. We touched a little bit on the recidivism tools, and those are changing the practice of litigation, and they are predictive. So they're not the same kind of thing as predicting the judge outcome, but I would say that they are having a huge effect on criminal prosecutions at the pretrial stage and at the post-conviction sentencing stage, not at the evidence stage. So that's where they're coming in, and I think that we're seeing the problem of lack of procedural rights in those pretrial and post-conviction settings is impeding our ability to contest those tools.
Great. And as Rebecca knows, I've done some research on predictive analytics, and one interesting finding is that just basic descriptive analytics of the kind Daniel was describing, forget about the advanced machine learning analytics, if properly contextualized, can dramatically improve predictions over pure intuition alone. All right, let me turn to Krister with our question for the panel.
Thanks, Harry. A lot of the, restraints around AI sound like it's related to science and implicit bias and the use of AI. Is there a role for AI to play in reducing bias in the courtroom?
Dan, you had commented on that earlier. Do you want to elaborate on that a little bit?
Yeah, I think it depends how we define, which kind of biases we're talking about. There's Daniel Kahneman did a study of Israeli parole boards, right? Where if it was before lunch and you're hungry, your chance of your petition being granted was almost zero, right? That's a kind of bias, and AI could help us reduce a bias potentially like that, making recommendations, things like that. I think that you look at some data about asylum grants by judges across the country, even within particular courts. And some judges granted very frequently, 40% of the time or something like that, and other judges granted almost never, right? Might we think about tools that could help make recommendations there that would reduce what seems to be bias and not just exercise of discretion in applying the law? I think there are absolutely plenty of opportunities to think about doing that. And I'm also particularly interested in thinking about, like in landlord-tenant court, right? Looking at landlord-tenant proceedings. The vast majority of tenants aren't actually going to go all the way to court. And even when they do, I'm not so sure that outcomes are consistent and the law is applied the way that we would expect it to be applied. And can we create tools, though, that can help tenants better understand what their rights are and understand when they actually do have a winning case that they maybe should pursue, or maybe even get a lawyer involved? And, so I think that there's a lot of potential in areas like that. And we just have to be thoughtful about some of the potential risks when we're introducing these tools.
I think one of the issues is we don't have great baselines. So if we don't know how biased the judges are in the first place, it's very hard to tell if the tool's doing any better. I think another thing we've seen, and Rebecca probably knows this well, is people are influenced by the score that pops out of an AI tool. So imagine you're a state judge and you're up for re-election this year, and out pops a risk assessment score that says 8 out of 10 likelihood of recidivism. You're going to think, well, I'm safer to jail this person than to let them go, because if they go and kill somebody, I'm not going to get reelected. So there are all kinds of factors, whether explicit or implicit, also where these numbers can impact. So I think it's a thorny issue. I think the potential is there, Krista. I don't know how we get there without better data and better research on how these predictions impact judges.
Rebecca, any thoughts?
Yeah, I do think there's an opportunity. Let's have AI tools that will predict when police officer witnesses are likely to perjure themselves on the stand. So where are those tools? Certainly an opportunity for technology to address some of the structural biases already built in the system, but I don't see them being developed, and I think it's because of the market failure.
That's a great point. And one point that Dan made earlier is that, data can certainly be biased in various ways, either just in the neutral sense of distortion and being unrepresentative, or in the way we commonly use it as having racial, ethnic, gender, or other undesirable biases. But judges, humans are also biased too. So at least in some cases, data offers us the opportunity to make those biases explicit and identify them, whereas we can't peer into judges' brains, at least not yet. So let's turn to another question, which might be our final question because we're running out of time. So Ebony says, who foots the bill? With advanced technology development, we often see huge government grants for the DoD or NSF and private companies funding research in houses at universities. But what about AI and law, basic AI and law research that could help society? Who's going to foot the bill for that? So let me throw it out to our panel.
I think that's a great question. And so Maura referenced earlier NIST, right? Investing in the track. I mean, that's great. The National Science Foundation recently had a call for designing accountable software systems. And the idea was that we ordinarily think of people being accountable under the law, but now we need to develop machines that are accountable under the law. Now, fortunately, the NSF was calling for legal researchers to be involved in that, but I think it's an example of hopefully we'll see more and more NSF funding and funding from other governmental organizations to promote research in this space, and we in universities need to do a better job of applying for that and showing the opportunities to invest in and the the benefits that'll come from doing that research.
And I think to Dan's point, grant funding has a tremendous impact on what research gets done. So if your funder is commercial, private company, they're going to be interested in something that helps their product or their commercial venture. If your funding is by the Department of Defense, they're going to want a military application. There is funding available. It's not huge, but there is funding available for in the nonprofit sector for where some foundations fund access to justice research. But a lot of it is where the priority of the funder is. And unless it's not necessarily aligned with the areas that we're talking about as areas of interest to us as legal people in legal justice.
Rebecca?
I don't have a lot to add. I think they've said everything there, but the NSF call was an optimistic one.
Yeah.
You know, Harry, just one other quick thing in this. Jason Taché wrote an article just recently about China's investment in platform technologies and the opportunities here, right, to think about not just developing technologies for here in the US, but we should be working with governments around the world, right, and thinking we care about rule of law, look at the way these technologies are impacting court systems and legal systems. We should be thinking of, that's the other, we need it here at home, but we should be thinking around the world and the impact that these systems can have in other jurisdictions as well.
That's a great point, and we can really leverage the sort of worldwide resources. So countries like Singapore, for example, are famously interested in legal informatics versus other countries that might not be as much on the radar. And I would also issue a plea to all the foundations out there who are looking to make high impact investments. This is one area that's really under the radar of most foundations, but can really, I think, make big impacts out there in the world. So we are unfortunately out of time, but I want to thank my excellent panelists for really interesting state-of-the-art and topical discussion. Maura, Dan, Rebecca, thank you so much. It's really been a pleasure talking with you. We're going to have a...
Thank you.
Thanks.
Thank you.
Thank you.
We're going to have a 15-minute break now, and we'll return at 30 after the hour for our third panel. So thank you so much.